Texas Attorney General Ken Paxton says the Biden administration is trying to get in the way of Americans' rights to privately buy and sell guns. The lawsuit AG Paxton announced today comes in response to new ATF rules aimed at closing the background check loophole. So he and other attorneys general are suing. The new rules expand who has to register as a licensed gun dealer. AG Paxton says it's unconstitutional.
This pistol brace was sold in 2012. A guy walked into a gun store, bought it legally, walked out of the gun store with the pistol brace.
You can argue how they interpret it, but here's the bottom line. They're dead wrong, and they're dead wrong for America.
According to recent rulings from the Fifth Circuit Court of Appeals, the Texas Suppressor Freedom case seeks to have suppressors manufactured in Texas exempted from regulation by the National Arms Association and the ADF. Analysis of Paxton versus DeBatch ruling. We're going to talk about a case called Paxton versus DeBatch, which we've been following closely. The Fifth Circuit has ruled in this case, and unfortunately, it's not great news. The court has sided with the lower court and agreed that the plaintiffs in this case are the ones who should be removed from the NFA and ADF's regulatory framework. Last July, on cross motions for summary judgment, a federal district court issued an order granting the ADF's motion for summary judgment. If you aren't aware of what a motion for summary judgment is, it's simply an early mechanism for a court to resolve a case. That's what happened here. Ultimately, the judge believed that the plaintiffs in this case lacked standing to bring the lawsuit and therefore ruled in favor of the ADF. The court also found that the state of Texas couldn't stand in the place of its residents to sue the government to essentially stop this application of the NFA towards made-in-Texas suppressors. After that, Texas appealed the ruling to the Fifth Circuit Court of Appeals, and it went in front of a 3-judge panel. The main argument in this appeal was whether or not the plaintiffs, the individual plaintiff, and the state of Texas had standing to have this case proceed forward. The 3 judges that reviewed and decided this case were Edith H. Jones, a Reagan appointee, Edith Brown Clement, a Bush appointee, and Corey Wilson, a Trump appointee. Edith Brown Clement, who was appointed by President Bush, was the one who gave the opinion of the court.
It does not have a state-level ban on bump stocks, and so now here in Pennsylvania, bump stocks are, for all intents and purposes, totally legal.
What happened in Las Vegas, it is a terrifying thing to consider the great evil that can be committed by one of these. Practicality, a machine gun on the street. So it is something that is scary.
Nonetheless, all 3 judges reached the same conclusion, which meant that there were no dissenting opinions. Every single person was on board. As a result of their conclusion that the individual plaintiffs didn't have the legal right to file a lawsuit, the decision of the lower court was affirmed, and the ADF has, for the time being, prevailed in this matter. In addition to this, they've discovered that the state of Texas was also lacking in standing. We're going to look at the 2 main reasons why this court found that the individual plaintiffs lacked standing, and then discuss how this case isn't dead at all. Likely, this is just going to move into a new phase of this lawsuit, and maybe there's even going to be an appeal up to the en banc panel in the Fifth Circuit to review what this 3-judge panel just decided.
The Supreme Court made a decision last week that he didn't like. Welcome to another day in the Democrats' summer of show votes. A 6-3 majority of the Supreme Court ruled the Bureau of Alcohol, Tobacco, Firearms, and Explosives overstepped their authority. The Supreme Court made the right decision, urging the Supreme Court to do what they did. So the majority leader has decided to bring up a bill called the Bump Act. Claims this bill will ban bump stock. The Bump Act targets common firearm accessories, not just bump stock.
The 2 main reasons that the court found the plaintiffs lacked standing were: the court said that their declarations were insufficient to show that there was a serious intent to engage in this conduct. The court said that there was no time period of the conduct alleged in the declaration. It was finally determined by the court that there was no standing in this lawsuit due to the 2 primary points that were brought forth. According to the court's decisions, the declarations didn't provide sufficient evidence to provide a serious intention to engage in behavior that's prohibited by the law. To begin, the declarations provided no indication that the parties intend to engage in any behavior that's prohibited by the law. The declarations, on the other hand, merely declare that the individual plaintiffs intend to privately produce an armed suppressor for their own personal use that's not for commercial purposes. In spite of this, the federal government has pointed out that the legislation in question doesn't ban the individual plaintiffs from producing a weapon suppressor under any circumstances. Rather, they simply restrict the production of armed suppressors that don't conform with the procedures and requirements that are applicable.
My message to Joe Biden yesterday, today, and forever is this: come and take it. Today's lawsuit is my great honor to stand up to protect our constitutional rights from the out-of-control federal government.
If you are engaged in the business of dealing firearms, meaning commercial activity, that regardless of where you're selling firearms. So if you're selling firearms at a gun show, online, a flea market, anywhere else, you need to become a licensed dealer and run background checks.
Future legal actions. In this case, the court emphasized the necessity of detailed declarations to establish standing. They pointed out that applying for approval, paying the requisite tax, registering the suppressor, and labeling it with a serial number are required steps. The court highlighted that the individual plaintiffs only stated an intent to personally manufacture an armed suppressor, but didn't specify whether they intended to do so without government approval. They also didn't claim that they were statutorily ineligible for such approval. Because the plaintiffs failed to show that their intended conduct fell within the scope of federal law prohibitions, they lacked standing to bring their pre-enforcement challenge. Essentially, the court found that the plaintiffs didn't allege an intention to make suppressors without going through the necessary legal process. This omission was a critical point for the court.
For the Senate to consider my legislation, the Banning Unlawful Machine Gun Parts, or BUMP, Act. More than 20,000 people gathered for a large outdoor music festival. No one could have anticipated the nightmare that was about to unfold then. Then over the music, they started to hear what at first people thought were fireworks. Complete panic erupted. Rapid gunfire rained down on the crowd with shots so close together that they seemed to almost bleed into each other. Concert goers ran in every direction, searching for cover where there was none.
The court felt that this was a significant oversight and used it to rule that the plaintiffs didn't have standing. Additionally, the court found that the declaration lacked the necessary detail to establish that the plaintiffs' professed intent to make a silencer was sufficiently serious to render their feared injury imminent rather than merely speculative or hypothetical. The plaintiffs didn't specify a time period for when they intended to make these suppressors, leaving the court to view their intentions as too vague and hypothetical. The court cited other reasons to illustrate their point, such as the Antonio case out of New York regarding concealed carry. In this case, the Second Circuit found standing because the plaintiffs had specified that they intended to carry at certain locations on specific days or time periods. This level of detail was missing in the Paxton versus DeBatch case, leading the court to rule against the plaintiffs on the basis of insufficiently detailed declarations.
I cannot tell you how important it is to have their support.
His war on our Second Amendment rights must be stopped.
The Biden regime gets 4 more years. They are coming for your guns. The survival of our Second Amendment is very much on the ballot.
Cured by Texas Attorney General Ken Paxton ended overnight.
We will not let Biden continue his tyrannical abuse of power.
Addressing standing issues and potential appeals. In the Paxton versus DeBatch case, the court highlighted that for the plaintiffs to establish standing, they would need to outline specific details. For example, they would need to say, "We intend to make suppressors by this time period," and provide evidence such as the items they've bought and the specifics of what they plan to make. The court found that the plaintiffs didn't provide enough detail in their declarations. The court also noted that there's a fine line between violating the law and making a claim. Plaintiffs can't go as far to violate the federal law by already making the items in question, but they also can't be too vague by simply saying that they might engage in this conduct sometime in the future. The 3-judge panel in the Fifth Circuit believed that the plaintiffs didn't provide enough specifics to show a serious concern, to show a serious intention to engage in the prohibited conduct. Although they don't necessarily agree with the decision, the panel ruled in favor of the ADF and upheld the dismissal from the lower court. This ruling was based on the lack of detailed declarations from the plaintiffs. You may be asking, where does this case proceed from here? There are a few options. Refilling with improved declarations. the state of Texas or the individual plaintiffs could address the issues in their declarations by providing more detailed and concrete information. They could then refile the lawsuit with these improved declarations, potentially curing the standing issues identified by the court.
2.7 million people are now felons in possession of firearms for something they purchased legally.
People were on notice for years and years and years.
Congressional Research Service says there are 10 to 40 million of those things purchased in the same period of time were received by the ATF. Does that sound accurate? A low-end number of the ATF numbers on 3 to 7 million. U.S. Fish and Wildlife comes to his car and sees a gun in there with a pistol brace. What's the penalty for him now? He bought the gun legally.
Appealing to the en banc panel. They could appeal the decision of the 3-judge panel and seek a review by the en banc panel of the Fifth Circuit. However, this may be unlikely to proceed. The original panel consisted of favorable judges, a mix of Trump, Bush, and Reagan appointees, and they all found issues with the standing. Filing for an en banc review might not yield a different outcome. In summary, the best course of action for the plaintiffs might be to address the court's concerns by providing more specific and detailed declarations. They should outline their intentions, timelines, and the steps they plan to take to demonstrate a serious intent to engage in the conduct in question. This approach could help them overcome the standing issues and allow the case to proceed. While this isn't the news we wanted to hear, we all anticipated this outcome given the standing issues. Courts often use standing as a means to defer matters they choose not to address. We'll be watching closely to see what steps the state of Texas and the individual plaintiffs decide to take next.
I mean, it's really a sad time for a court to make that kind of ruling. You can argue how they interpret it, but here's the bottom line. They're dead wrong, and they're dead wrong for America. It's not a machine gun. That's not a silencer. It is a silencer. I mean, I don't know what the Supreme Court's going to do. Are they now going to be the ATF? Because the country can't work that way.
Well, guys, that's going to do it for this video. See you next time, and bye for now.